application in the matter of HM.
Yes.
My Lord, I appear on behalf of the appellant in this matter. And my own friend, Mr. Milonis of His Majesty's Council, appears on behalf of the King's
The hospital trust.
Hospital. And my own friend, Mrs. Sophia Roper of His Majesty's Council, appears on behalf of the official solicitor.
Thank you. Right, a couple of preliminary points before we start.
Yes.
First of all, this hearing is being live streamed. I received no notice of any objection to that course. So it is being live streamed in the way which proceedings in this court usually are.
Yes.
So that means, for the benefit of everybody who's in court and may not know, that these proceedings are being live streamed via YouTube at the moment. That's the first point. The second point I want to say is a thing I want to say. Mr. Thomas, the court's very grateful to you for appearing at short notice on behalf of the applicant today. Thirdly, we would like to be just introduced, just told who is in court. I apprehend that there are family members in court.
Yes.
Without identifying them by name, can you just tell us what the position is?
Yes, sir. Back, my Lord, in the far left-hand corner is my client, who we're referring to as Miss XZ.
Well, we'll come on to what we're going to call them in a minute.
Yes.
So the applicant is in the far left corner.
Just sitting in front of her to her left is her aunt, I understand to be
in
ex-wife's-
white.
sister.
Right, sister.
her
Yes.
aunt. And then to also in the back row, the gentleman is Miss XZ's grandson and my client's son.
Right.
So those are the people present.
Thank you very much.
In my clan.
We want to say that we're very pleased the family are here today. We're very sorry that because we don't want to mention names in this court, that it all sounds very odd and impersonal, and I regret that, but it's important, and unless anybody says otherwise, it's important that we don't publish give the names of the individuals or anybody else involved. Do you understand that? Mr. Thomas, can I understand, just having said that, is that still the position of the parties, that this case should be anonymised?
Well, that is still the position. I'm very grateful to my learned friend, Mr. Blonis, who's going to assist with the reporting restriction order, which a copy of which I think has been provided to the court.
It has. Now, the position Mr. Milonis rightly apprehended that my reason for asking about the reporting restriction order was that the transparency order in the Court of Protection does not apply in this court. So we have to go through the reporting restriction order process. Normally we have more time to do this, but because of the short notice, because he brought this application on very urgently, we haven't had time to do this as promptly and or as efficiently as is sometimes the case. Thank you very much for the draft. This morning I asked the court office to email you to say that we would plan, as we have done in other cases, to include a provision about the skeleton arguments. In other words, complying with the practice direction that the party should make available anonymised versions of the skeleton argument, not anonymised, redacted versions of the skeleton arguments for service on accredited law reporters, accredited media reporters, and anybody else we thought should have we agreed should have a copy.
I'm grateful for that. Ms. Roper had flagged that for our attention last night, and we have hard copies here should any members of the press be in court. But of course, having hard copies, they are also in electronic format.
Right.
If anybody requires them, they can approach myself or my instructing solicitor, and we will email them.
This morning, we have had, the court office had an email from Professor Kitzinger.
She has been sent we have seen that, my lord, she has been sent the skeletons. She had also in that email asked about the judgment.
Yes.
I had sent an email this morning very urgently to Mrs Justice Arbuthnot's clerk, asking whether we could circulate what we understood to be the final agreed, corrected, clean version of the judgment. I understand she was dealing with urgent applications and she had not managed to provide a response by the time we...
Well, you're ahead. I had thought that there wasn't an anonymised version of the judgment available, because rightly or wrongly, the version I've been working on
Yes.
is not anonymised. So that's why we weren't able to send a copy to Professor Kitzinger this morning.
My lord, I anonymised one last week and provided to her ladyship for approval.
Okay.
I haven't yet had a response, but again, that's ready to go out.
All
If
right.
your lordship's content, it might be difficult because your lordship wasn't there in the court below, so I'd rather wait for...
Well, I think it's not my judgment. It's not our judgment. It's Mrs Justice Arbuthnot's judgment. So I don't think I'm in a position. We're in a position to counter that. To say that I apprehend she will agree. But is there anything more we can do? Do you think to deal with that?
And indeed, I had been in touch with Miss Kitzinger last week to say that we were awaiting approval of the judgment and we would forward it. So that is, we are doing everything we can to be transparent and to circulate both the judgment and the skeleton.
Good.
Skeletons have already
Well,
gone.
thank you very much. If in the course of the morning you would like you get a response from Mrs Justice Arbuthnot, please could your team ensure that a copy is sent to Professor Kitzinger and anybody else who fits the criteria that we've laid down.
I'll do that, Lord. And can I confirm also, I will include the paragraph which Miss Whitby kindly forwarded to me, at your lordship's suggestion. We'll include that in the explanatory order in the RRO, and we will reserve on copy direct.
Thank you very much. So just for the I should just formally say that we make the reporting restriction order in the terms drafted by Council, subject to that amendment about the skeleton arguments, the consequence of which is that nothing must be published. In short, nothing must be published that identifies the subject of these proceedings. That's in essence what this is about, because this court is in public, but nonetheless these proceedings are subject to that restriction. Now, are we going to be calling the subject of these proceedings XY? And that's a very impersonal thing to be calling her, but it's probably the best course in the circumstances, is it? I know she was referred by something else in the court below.
My lord, I think when the anonymisation was first conducted by Mr. Justice Peel on the 27th of September, her real initials were used.
That's
which wasn't
right.
terribly helpful. She has a nickname, and she was referred to by that in the.
And
court
Mrs
below.
Justice Arbuthnot, that's what's in the judgment, and that's
Well,
what the
and-
family call her.
Indeed, and it was a much more realistic and friendly way
know.
of responding to it. But given that these proceedings are in
Yeah.
open court and are live streamed,
But that's why I said what I said to the family. It's going to sound very impersonal calling her XY, and I'm sorry about that.
I know.
Much rather call her by the name that they all know her by.
I
But
know
I
that
don't
Mr.
think I should
Thomas
in the circumstances.
has explained that to her. And the
Okay.
reasons for it.
All right. Anything else you want to say? Okay, so now we have received copies and read the two bundles, the core bundle and the supplemental bundle. We've received, I think, really 3 skeleton arguments from your side, Mr. Thomas. So with the initial document drafted with the grounds of appeal, then a supplemental skeleton, which is the one Mr. Milonas responds to, and Ms.
Yes.
Roper. And then you very helpfully filed a further document yesterday or
Yesterday.
very recently.
Well, yes.
Yes.
Those are, as I understand it, all the documents that need to be before the court
Yeah.
today. I'm very grateful for your indication that you've had the opportunity to consider those.
We have.
Lord, I'm going to start with a brief summary of what brings us to court today.
Yes.
I will be brief. This application and this appeal concerns XY. She's a lady in her 50s, a mother and a grandmother, with some previous health problems, but nevertheless fully active socially, with family life and of friends.
Well, she's
and
got a large family.
absolutely,
Many of whom are here,
yes.
and others. Is it? Can we say where they're living? Is that where the family other
Well,
family,
well,
extended family live?
It's no secret, given that obviously she is at King's, which is a hospital local to where she
Okay.
lives.
So no, but I meant which part of the world the other family members are living in. Is that
Yes.
There's no secret about
No
that.
secret about it.
Okay, she's got lots of family living in Jamaica,
Yes,
including I think her own father. Is that still right?
yes. And this case is, of course, of great importance to all of those people.
Of
She
course.
was plainly a very loved, cherished member of that family and of that community. And she,
And a member, and this is crucial to your case, a member of the local, an active member of the local.
well, yes, and I, of course, we'll be coming to that very, very shortly. She enjoyed life to the fullest, although she had, as I said, some previous health problems we'll need to touch on briefly shortly. On the 6th of May of this year, she suffered a sudden cardiac arrest at home. She was discovered by a family member.
Yes. Well, we've read about that, and it must have been deeply distressing for that person.
Yes.
Say no more about that.
We need say no more. The ambulance was called, and although the ambulance and paramedics attended fairly promptly, really very promptly,
Yes.
it nevertheless appears that she probably had a period of approaching an hour, during which there was at least a degree of hypoxic injury, both to her brain and to other organs, including her kidneys.
I think the medical evidence was that it was overall more than an hour, Mr. Thomas.
Quite possibly.
A short period before the ambulance arrived, and mercifully, it was a relatively short period compared to what one hears about in other cases.
Yes.
And then the period trying to resuscitate her was
Yes.
over an hour.
So she was admitted to hospital. She was resuscitated successfully, admitted to hospital in a coma.
Yeah.
At the time of her admission, she quickly developed, or had breathing problems, and quickly developed kidney problems.
Yes. And liver problem, I think.
Yes. And she has recovered significant kidney and breathing function. And we'll come, of course, in due course to the extent of her breathing in a moment. But significantly, she remains, and there's no dispute about this, significantly brain damaged as a result of that period of hypoxia.
But she's come out of the coma.
She's no longer in a coma. She is in what is currently described as a prolonged disorder of consciousness. The precise label perhaps doesn't matter. It's her individual condition that matters.
Well, doctors talk about these in different language from the language they used recently.
Yes.
And they talk about there being a spectrum,
Yes.
so a range of disorders.
Of differing
Yeah.
causes, differing durations, and differing prognoses.
Yes.
But she nevertheless falls into that category of a prolonged disorder of consciousness. Her awareness is limited. The extent of her awareness is a matter of some dispute between the family and the medical staff, again, which is a matter I'll come back to. So whilst there is a significant degree of agreement between the family, including my client, and the medical staff, there is a difference of views about the extent to which XY is aware of and derives any comfort from the presence of her family at her bedside. She is currently breathing with the intermittent and potential assistance. She's breathing via an endotracheal tube.
Yes.
She has a mouth guard to prevent her teeth from clamping down on her tongue. That mouth guard requires hygiene care.
Yes.
And she is also dependent.
We've read about the issues that there have been about her, about biting her tongue.
Yes, and she requires nutritional support and hydration as well, of course, being unable to feed or drink for herself.
That's via a nasogastric tube.
That's via a nasogastric tube. And in those circumstances, the medical staff at the hospital reached the view that from their perspective, it was no longer in XY's best interests for this treatment to be continued. It was clear the family did not agree and does not agree with that position. thus the need to apply to court for a declaration.
Before they got to the court application, the trust sought a second opinion, I think, a further opinion from two people, from Professor Wade
Yes.
and then a professor, I forgot,
Professor Osterman.
Osterman, who is a,
There's an intensivist at Guy's and Thomas's.
that's it.
Professor Osterman was in fact contacted after the
Start of proceedings.
after the start of
You're right,
proceedings
I'm sorry. But
as a result of
Professor,
the
was
declaration.
is it part of the protocol for dealing with these cases that the trust will ordinarily seek a second opinion
Yes.
from an external specialist before coming to court?
Yes.
And is that what happened in this case with Professor
My
Wade?
understanding is that what happened in this case, and so whilst Professor Wade was instructed before the application was brought, he remains effectively the witness, or the principal witness on behalf of the hospital in that application, or in this application. As a result of the directions given following the application being issued, my client had legal aid at the time and had a firm of solicitors acting for her, and a Dr. Bell was instructed through my client's solicitors, and he provided a report, and that report is also in the supplemental bundle. My client does not agree with some of the conclusions of Dr. Bell, and I will come back to that disagreement again as in part of my submissions. The hearing then took place before Mrs Justice Arbuthnot on the 5th and 6th of November, and the judge gave judgment on the 11th of November, in which, over the course of a lengthy written judgment, she concluded that it was not in XY's best interests for that treatment, the clinical assistance by nutrition and hydration, to continue. My client seeks now permission to appeal from the decision of Mrs Justice Arbuthnot.
Could you just remind us what the position, what the order was about implementation of the judge's decision?
Yes.
Where and what discussions there have been about that?
Well, so the consequence, if I can just come to just a minute.
If we look at the order.
Yes.
The draft order.
The draft order is at
39.
page 39 of the core bundle.
Yeah.
And the declaration is seen at paragraph 1.
Yes.
And it is then ordered, or rather declarations made at paragraph 2, that it is lawful in XY's best interests to be treated in accordance with the palliative care plan. And that palliative care plan is seen in the supplemental bundle at E1. So it's the last 2 pages of the supplemental bundle. I should say the last. That is, in electronic terms, pages 229 and 230 of the supplemental bundle. That provides for the withdrawal of clinically assisted nutrition and hydration, extubation of the endotracheal tube, and following the withdrawal of that, active treatment, monitoring, and the provision of further medication and medical assistance in order to address any potential symptoms of pain and distress. And there is there the potential for XY to, the understanding being that the consequence of that is likely to be that XY will pass away sooner or later, either in hospital or potentially having been transferred from the intensive care unit, depending on the time frame. So that will be the consequence if permission to appeal is not given today, my lord, in the order that you made directing that this hearing take place, you ordered that if we go back to the original order of Mrs Justice Arbuthnot, page 39,
Yeah.
that the paragraphs 2 and 3 of the order be effectively suspended.
Yeah.
Meaning that at present the discussions as to the agreeing a date for the withdrawal treatment, those discussions are not currently taking place. Are not currently taking
Okay.
place.
Thank you. Just remind myself what I said. Yeah. So until this application is decided,
Yes.
that order is stayed.
The operative parts of the order are effectively
That's
stayed.
right, but that's what I intended to do. I'm glad that's what I managed to achieve. Yep.
And so, to put it in simple terms, my lord, if permission is not granted today, then that in in procedural terms will be the end of any prospect of appeal. My assumption would be that in those circumstances, the stay in relation to those paragraphs of the order of Mrs Justice Arbuthnot will be lifted and or varied, but effectively lifted, and the withdrawal of treatment will continue, or will take place in the short term.
Yes. Mr. Marlonis makes some points about that in his skeleton. Perhaps should we
Lord, yes, I think
come back to those after you can come back to those after we've heard.
I think it would be sensible to come back to that after we've heard the principal submissions. My view is that those don't impact on the principle or on the granting permission itself.
Thank you.
Rather, they're perhaps consequent on any decision the court makes in relation to that. My client did not initially have legal representation to pursue her appeal, and you have in the core bundle at page 13 the grounds of appeal.
Yes.
And then at page 21, a very brief skeleton argument.
Yes. Well, the grounds are actually, I thought, more fully set out than the skeleton on this occasion.
Precisely. The grounds look, well, they have some argument in support of the grounds, rather than simply stating what those grounds of appeal are. The first skeleton argument rather shorter. There is then a longer, I think it's a 14-page skeleton argument we have at page 24 in the bundle. And when I agreed to assist my client a few days ago, on reading the papers, it appeared to me and with my clients agreement that the court would benefit from focused submissions on two particular aspects of the appeal, two particular grounds. Those are grounds 2.1 and 2.3. If we turn to page 13. The
2.1. Yes, and 2.3.
Yes. Sorry, it's ground.
I thought it was 1.3.
Sorry, Sorry, it's 1.1 and 1.3. I do apologize.
1.1. That's
1.1
right.
and 1.3. I'm going to come on to sections or grounds 2, 3, and 4 in a moment.
Yes.
Because, my lord, it is apparent on looking at the grounds of appeal that there are a number of matters that effectively fall to be considered, I would suggest, as one.
Yes. There's overlap between the grounds, as
Yes.
unsurprisingly drafted.
The best interests protocol, which of course has arisen organically over many years, if followed satisfactorily, ought to meet the procedural safeguards required under Articles 2, 3 and 8 of the European Convention on Human Rights. That is to say, if the principles such as those set out in the agreed legal framework in this case are followed, a direction or a declaration that it is lawful for a patient's treatment to be brought to an end will not breach that patient's Article 2 rights, because the safeguards ensuring that her right to life has been protected in accordance with Article 2 will form part of the considerations of the best interests test. Similarly, in relation to Article 3, to the extent that that is relevant in this case, of course, in some cases where there is a greater degree of awareness, the discomfort that somebody may suffer through having treatment or through not having treatment are more apparent. And in those circumstances, again, those ought to be addressed via a thorough best interests analysis. And thirdly, in relation to the individual's right to a family life, and particularly here, of course, the benefit to XZ of her family, the ongoing benefit of that to her, that is something which ought to be taken into account in the best interests analysis. So for those reasons, my lord, I don't propose to argue this morning, at least for the purposes of permission, that specific considerations of Article 2, 3 or 8 need to be made. To put it bluntly, if the court is of the view that there is no real prospect of challenging the appropriateness of the best interests exercise completed by the judge in this case, then reference to Articles 2, 3 or 8 would not assist in that argument, because the court would effectively be finding that the protections afforded in those articles had been met via an adequate best interest analysis.
Yes.
There's one more article in the ECHR that we need to consider, which I will come back to, which is Article 9.
Yes.
That is a person's freedom to manifest their own religious beliefs. That is important in this case, but without diminishing its importance in any way, that is also a feature which ought properly to be taken into account in the best interests analysis of the individual patient. Because of course there will be some patients for whom their religious views are a matter of little importance in the best interests analysis. There are other patients, such as we would argue XZ in this case, where her religious convictions are extremely important and indeed ought to be one of the most important factors in the best interest analysis. And as I'll come on to shortly, we can see from the judge's decision that we would argue inadequate attention, inadequate weight was afforded to that very important feature of this particular case. Before I come on to, so that's the best interests. There is another ground of appeal that I have included in the argument provided yesterday, which is that the judge failed to attach sufficient weight to the evidence of my client and other family members as to the extent to which XZ is aware of and benefits from their attendance at the bedside, and the comfort she may gain from their presence, and that of course goes directly to her quality of life. So I'll come back to that shortly. The last umbrella ground of appeal, if I can call it that, of the sort of the groups of grounds of appeal, is that relating to expert evidence. My lord, I propose to deal with that fairly shortly, because I understand and anticipate that the court would require some persuasion that where a direction is given that a party instruct their own expert, an expert is instructed and in due course provides a report to the court, that could be said in normal circumstances to be procedurally unfair. There are three things that I need to highlight in relation to that. I will do so briefly. The first is, of course, that this is primarily an inquisitorial rather than adversarial jurisdiction. And so if it is the case that there was an inadequacy of expert evidence before the judge, whilst the directions that my client seek her own expert are intended to assist in that process, if in fact the outcome was that there was no independent expert, that is something that should trouble this court on appeal, and to trouble it very significantly. The second point is that, and without straying at all into areas of legal professional privilege, that the court can take judicial notice of the fact that parties to litigation will have varying degrees of active involvement in the selection and instruction of experts through the solicitor that they have appointed. There will be cases in which a party is intimately and very actively involved in that process. And there will be other cases where, for whatever reason, the party is effectively dependent upon their solicitor for selection and instruction of an expert, and they're rather dealt the hand they're given in that respect. And it's my client's position in this case that this case falls very much into that latter category. She was at the time dealing with the stress and the daily commitment of attending on her mother XZ at hospital. She was entirely reliant on her solicitors to identify and effectively instruct an expert. The outcome of which was that, yes, we have the expert report of Dr. Bell, but it was an expert that she says is not really independent of the medical establishment that have provided evidence for the hospital in support of this application. And that is something that the court should bear in mind in this appeal. So if I can move on to the first of the two principal matters I wish to make submissions on this morning. And I do so, of course, just to make the point very briefly. This is only, in inverted commas, a permission application.
Yes.
It is not, for example, at this point, necessary for me to demonstrate that the judge did get the law wrong.
No, you've got to show there's a real prospect that the
Lord, yes.
establishment judge
Yes.
got it wrong, or that there was a procedural, the outcome was unjust because of a procedural irregularity,
Yes.
or some other compelling reason why this appeal should be heard.
Yes. Well, my lord,
Which of those prongs do you rely on?
my lord, I rely on the prong that there is a real prospect of establishing that the judge made material errors in her assessment of the best interests determination in this case, for two reasons. The first is that she did not attach sufficient weight or give sufficient consideration to the evidence of my client and other family members as to the response that they could see from her mother, or can see from her mother, at the bedside at hospital. Secondly, and this is where perhaps I anticipate much of the debate maybe this morning, that the judge failed to take into account really at all, certainly to any, did not take into account to any appropriate extent, the evidence that was before her concerning XY's faith, XY's and what XY's wishes would almost certainly be in the situation. Where the judge made the observation at paragraph 112 of the judgment that one cannot know.
Yes,
what
so
wishes would be.
let me just see if we've got the focus. It's 112 to 114 was where I thought this was really
My lord, yes.
central to the judge's
Yes.
This is where the judge dealt with this point. Well, alludes to it at various points.
Yes.
This is her conclusion, isn't it?
My Lord, this is a passage headed discussion.
Yes.
Paragraph 103 says next best interests, and it's apparent from that that the following paragraphs really from 104 all the way to 131 it's tackling the best interests considerations, and is purporting to follow the legal framework and the case of P, where
Justice Cobb.
yes, where it's not a binding list, but it's an extremely helpful list
Yes.
of matters that should be considered. It may be helpful, my Lord, in fact, to turn to that at this point.
Mr. Justice Cobb.
Yes.
Right. This is tab 14, well, not tabs, page, will be tab 14, 493, is it?
Yes. It's paper page 493 of the authorities body.
Yes.
That case concerned a patient who, as we can see from paragraph 1, suffered a catastrophic stroke which left her severely disabled, brain damaged,
We can probably go
and
straight to the
incapacitated.
the approach that
We can-
he advocates, which
we
is,
can.
is it paragraph 9?
Paragraph 9, specifically, there's no issue here about XY's capacity, and so we're looking at 9.3.
Yes.
If she lacks capacity, is it in her best interest that I should confirm the continuing delivery of clinically assisted nutrition and hydration? In answer to this question, I should consider A, her previously stated views on life support and on sustaining life artificially in the event she is totally dependent on others and incapable of functioning in many essential domains of her life. B, the quality of her life at present. C, the prognosis if CANH were to continue for the foreseeable future and whether there is any real prospect of recovery. D, the prognosis for her if CANH were to be discontinued. What would the palliative care package include if that were, the CANH were to be discontinued, and where would that optimally be delivered? E, prognosis if the discontinuation of nutrition but not hydration were authorised.
Well, that's on the specific facts of that case.
Yes,
isn't
that
it?
doesn't really apply in this case, my Lord. F, the views, wishes and feelings of the family and her carers. G, her dignity, and H, the sanctity of life generally.
And the judge did follow that
Yes.
structure, didn't she?
Yeah, Lord, she did. And so where I say she purported to follow it, it's perhaps fair to say she did follow it. It's a question whether in following it she appropriately made appropriate determinations on the evidence before her in relation to those factors. Now, my Lord, those factors aren't, of course, in the order of importance.
No.
There is no set order of importance.
The importance of each factor will vary from case to
It
case.
will, of course, vary from exquisitely from case to case. Every case will be different. That's not a sop. It really is the case where you will have two patients on an intensive care unit. They may be clinically in very similar conditions, but the considerations for those two individuals may be very different indeed. However, having said that, there is no doubt, and the courts have repeatedly stressed, that the sanctity of life gives rise to the presumption, albeit a rebuttable presumption, that life-preserving care is to be maintained. And of course, the burden in satisfying the court that it is lawful to withdraw such treatment is on the party seeking that declaration here in the hospital. A second feature in relation to those factors identified in P is that the views of the individual patient the basis for those views and the strength perhaps with which they might hold those views are also always of central importance, sometimes described as magnetic importance. I think that's the words of Mr Justice Hayden, and must not be sidelined. And my client's case is that they were rather sidelined.
Wishes and feelings and values and beliefs is how the statute puts it in section 4.
Well, yes, that is of course a statutory requirement under section 4 of the Incapacity Act 2005, Mental Incapacity Act. Sorry, Mental Capacity Act 2005. And so the importance of the views of the individual, regardless of their reasons for holding those, are extremely important. And my Lord, if I can perhaps turn to one of the clearest and most colourful examples of this, it's the case of Y Valley NHS Trust and B. That is in divider 6 in the authorities bundle.
We don't have dividers. So
Sorry,
no, it's not. I don't.
It's page 150. Sorry, not 150. Wrong. Clicked on the wrong one. 189.
Why? That's not. That's AJ.
The perils of the digital bookmark.
I think Y is Lord Justice Peter Jackson, isn't it?
It is more.
Or in his previous incarnation.
Yes.
Mr Justice Peter Jackson. That's right.
Now, it's important to bear in mind, of course, in the case of B, the patient of that case was conscious, and whilst he'd suffered for many years with mental illness, which was the principal reason for him lacking capacity, he was nevertheless able to express clearly and articulately his own feelings and beliefs. But Mr Justice Jackson said at paragraph 13 of the case, bearing in mind this was expressed in the context of mental illness, it is still nevertheless important in general terms, because it goes to whether those beliefs are rational or whether they indeed accord with what the views of the court might be. He says, in some cases, of which this is an example, the wishes, feelings, beliefs and values of a person with mental illness can be of such long standing that they are an inextricable part of the person that he is. In this situation, I do not find it helpful to see the person as if he were a person in good health who's been afflicted by illness. It is more real and more respectful to recognise him for who he is, a person with his own intrinsic beliefs and values. It is no more meaningful to think of Mr B without his illness and idiosyncratic beliefs than it is to speak of an unmusical Mozart. Then at paragraph 14, the judge identifies that some of his beliefs might be described by others as religious delusions, but he concludes, it's halfway down the paragraph, Mr. Billy's religious sentiments are extremely important to him, even though he does not follow an established religion. Although the point does not arise for determination in this case, I approach matters on the basis that his Article 9 right to freedom of thought and religion is no less engaged than it would be for any other devout person. He goes on at paragraph 15. This is another manifestation of the principle that the beliefs and values of a person lacking capacity should not be routinely undervalued. Religious belief has been described as a belief that there is more to be understood about mankind's nature and relationship to the universe than can be gained from the senses or from science. Religious beliefs are based on faith, not reason, and some can strongly influence the believer's attitude to health and medical treatment without in any way suggesting a lack of medical capacity. Examples include belief in miraculous healing or objections to blood transfusions. And there's then a comment on blood transfusions and the individual here, somebody with schizophrenia who poses an amputation. Before Mr. Justice Jackson says, while the religiously based wishings and feelings of the former must always prevail, as somebody who refuses a blood transfusion, it cannot be right that the religiously based wishes and feelings of the latter, as somebody who is incapable, must always be overruled. That would not be a proper application of the best interests principle. So that is a very clear reminder, if it were required, that somebody's religious beliefs, really regardless of the basis for how they've come to those beliefs, are an integral part of who that person is. And one is not to apply any kind of value judgment on the reason why they have come to those beliefs. And they are not to be lightly overruled. That principle is, again, comes to fore in the case of Royal Bournemouth and Christchurch Hospitals NHS Foundation Trust and TG. That is at page 524 in London Law. Now, it is only right that in talking about the case of TG, I identify that that was an application made rather earlier in the treatment pathway than we have here for Miss XZ. And part of the court's ultimate decision in that case was that the application had been brought less than 6 months after the traumatic event, which in that case was a massive subarachnoid hemorrhage. And so the window for improvement in brain function, the court found, may not in that case necessarily have closed. But the observations that I wish to draw to this court's attention today are quite separate from that aspect of the case.
Are they part of the ratio?
My lord, they plainly are part of the ratio.
Thank you.
Firstly, in paragraph 19 of the judgment, the Mr Justice Cohen stated the following: the law has moved on since Bland. There are 2 other passages of the authorities of particular relevance. First is paragraph 62 of Briggs, number 2, citation given.
Forgive me, Mr. Thomas, which paragraph are you reading from?
This is paragraph 19, my lord.
I do apologise.
Page 527.
Thank you.
Where the judge refers to Briggs.
Mr. Justice Charles.
And that quote is in the top of page 528.
Yes.
Where it's Justice Hayden said in that case, but in my view, sorry, Mr. Justice Charles said, when the magnetic factors engage the fundamental and intensely personal competing principles of the sanctity of life and of self-determination, which an individual with capacity can lawfully resolve and determine by giving or refusing consent to available treatment regimes. It says the decision maker and so the judge must be wary of giving weight to what he thinks is prudent, or what he would want for himself or his family, or what he thinks most people would or should want. Well, that is a significant principle, which I'll come back to when we look at those crucial paragraphs of Mrs Justice Arbuthnot's decision. And then, if the decision that P would have made, and so their wishes on such an intensely personal issue, can be ascertained with sufficient certainty, it should generally prevail. A passage goes on to say it should generally prevail over the very strong presumption in favour of preserving life, because that was a case where the indication was that the person would not have wished treatment to continue. But the observation is, of course, the same, if not stronger, if it applies in a case where the person's personal wishes can be ascertained with sufficient certainty and actually support the presumption.
Do you have an authority in which that it was that way round to cite?
Well, my lord, I do.
But I don't just lead you astray. You wanted to say something else on this?
I wonder if we could finish with this
Of course.
judgment, and then because this judgment does that case that the judge was quoting at paragraph 19. The case of Briggs was one where the views were against or in favour of the cessation treatment, but this is a case where the views of the individual, this case of TG, could be ascertained and were in favour of the continuation treatment. So this is one such example of that. So we turn to paragraph 24. The judge states in that case that he was particularly struck with some of the evidence from the evidence of the family members. But 4 lines down, stating they have 2 principal strands. First, if her presence was a comfort to others, as I find it to be, she would want to be there, whatever the cost to her. And Lord, as we will see, that is very close to the family's evidence in this case. Family was central to her, and she would want to remain a part of the family, no matter what form it would take, for as long as possible. Secondly, she had the utmost respect for life because of its intrinsic value, and that it was for no one other than the Lord to take it away. It is for him alone to end, and she would never accept anyone else facilitating death. Again, my lord, that is very close, as we'll see shortly, to the evidence of ex-wife's family as to her views. And then the court goes on to discuss specific incidents in which she had had conversations with her family. The court then says at paragraph 25, I agree with what Mr. Roper said on behalf of the official solicitor, that this is compelling evidence that TG would not have consented to the endotracheal tube being removed, and she would have wanted to benefit from the opportunity to live and take whatever chance is offered, however small, of an improvement in her condition. The judge then poses the poignant question at paragraph 26. 3 lines down, having identified this as an irreversible decision that would have lead to TG's death very quickly. He says, I am being asked to do so in the face of what I find, in the face of what I find are the wishes and feelings of TG. I ask counsel if they are aware of any case in which the court has terminated life support against the wishes of the patient. And they were unable to tell me there ever was one. With the quality of expertise before me, I'm sure that there must therefore not have been such a reported case. Now, whether or not there may have been situations on which life support has been discontinued against the wishes of the patient, that is plainly or would be a very serious step to take indeed.
I don't think you've cited the Aintree case in this bundle of authorities, have you?
Well, no.
Because Baroness Hale did touch on this, didn't she, in the Aintree case?
Lord, hang on. Yes, and give me just a moment. I think the passage that you are referring to is
Paragraph 45, perhaps.
Yeah, I think that may
Which
be.
we don't have in front of us. But
I think it may be cited in one of the cases we do have in front of us. Give me just a moment.
I would imagine it's cited in quite a lot of the cases.
Yes. Sorry, misbehave. No, it's all right. Thank you. Yes. Yes. I think, my lord, the passage you're referring to is where it was said the purpose of the best interest test is to consider matters from the patient's point of view. That is not to say his wishes must prevail, any more than those of a fully capable patient must prevail.
Well, that was
We cannot always have what we want.
that was the passage in my mind.
Yes.
But I would I wondered if there was more that Baroness Hale said on the particular point that you've been making.
Well, my lord, I may need to take some time to check on that, but nevertheless, of course, it is the case that whatever a patient's interests are, views are,
Yeah.
however clearly expressed those may have been before an event such as this. Yes. One cannot get to the point where medical staff are forced to give treatment that they regard as unethical, and so there has to be that in itself is an example of the situation where, as Baroness Hale said, one doesn't always get what one wants. There has to be a limit to the principle that one ought to give effect to the patient's wishes. Well, I'll come back, if I may, to what she went on to say later in the Aintree case. So what we have there, my lord, are very clear examples of the principle that where somebody has strong religious beliefs, they are to be respected, and insofar as is reasonable and possible, will be a significant factor in the best interests analysis. So, Lord, having identified some of the key authorities in this area, I'm going to return then to the facts of this case. My lord, it may be helpful at this point to have the judgment in front of you. The position at the hearing was that we look at, perhaps having said having the judgment in front of you, my client provided a lengthy witness statement,
Yes.
which had a number of appendices setting out statements, or informal statements of a number of matters.
So this is in the supplemental bundle.
Yeah, that is in the supplemental, but if we were to turn to that statement, you can
22.
see
C22 it
so
starts.
it's C22.
And your client has appended to that statements from other family members.
Yes. And I'll come on to what they say shortly. She gave oral evidence at the hearing, and
Yes.
3 members of friends and family
Yeah.
also give evidence whose witness statements are not in the bundle, and their evidence is summarised in the judge's decision. The judge, there was no, I am told that there was no substantial challenge to the evidence by any of those 4 witnesses at the hearing, nor was there, as I am informed, any questioning that might lead to the conclusion or submission that their evidence about what XY would have wanted was influenced or had become perhaps changed or from what it might have been if they'd been asked rather earlier in the process. Because, of course, people's views and recollections can change over time. So there's nothing to suggest that the views of my client or any other witnesses were inaccurate.
Unreliable, perhaps.
Unreliable, yeah. Unreliable in their
There
descriptions.
was no it wasn't suggested. Is this your case? It wasn't suggested to them in evidence that their evidence about what she would have wanted was unreliable.
More precisely. Neither was it suggested that their evidence about what they had seen and witnessed at the bedside was itself unreliable. As I understand it, it was, of course, the case, there's no secret about this, that the interpretation of what they could see was not accepted by the hospital or by the hospital's witnesses, or indeed by Dr. Wade. Nevertheless, the judge found that my client, the appellant, visited her mother in hospital nearly every day. Those were not brief visits, so we're talking hours, pretty much every day over a period of 6 months.
Are you dealing with the wishes and feelings point or with the observations point?
This is the observations point, Lord. This is really the first of the principal grounds of appeal.
Right.
She was able to give specific evidence of her mother responding to people and to events in the room.
There was a video or videos taken.
Yes.
Which were shown to, I can't remember if it's Professor Wade or Dr. Bell.
Yeah, Professor Wade. Yes, and his interpretation of what those videos showed was, in his view, brain stem activity rather than awareness. But the importance in a case such as this of the evidence of the individuals have spent a quantity of time, prolonged periods of time with the patient, should not easily be discounted, or should not be discounted.
This was a case where there wasn't any, and again, I think it was Professor Wade who talked about this, or maybe Dr. Bell. There weren't any structured observations applying the so-called WIM test.
No.
The other structured tests.
No, my lord. There's, as I understand it, there's been no structured survey of over time, counting the number of and categorising the movements and trying to put those into the context of environmental changes in the environment around the patient. However, there is evidence that from the appellant and from other friends and family that XY, not always, but will squeeze their hand when asked, will blink when asked, will turn towards them. If we could just briefly consider her witness statement, which is in the supplemental bundle. Hopefully, my computer is now. Yes, it is now behaving itself again. Yes, no, it's fine. It's okay. So if we turn first of all to page 124.
I'm afraid we haven't got any. We're both working off the paper copy. As I am.
Yes, this would be. It's page C30.
Thank you.
Supplemental bundle. She says, since my mum has been in hospital, she has improved a lot, and her medical team have sometimes recognised this, but not always. When she was first admitted to hospital, she couldn't open her eyes, and she did not respond to anything around her. She was very unwell. From around June onwards, so that's about a month in, she started to open her eyes and look around the room.
Well, that's the emergence from coma, isn't it?
Yes. So that, and everyone agrees there was an emergence from the coma into the prolonged disorder of consciousness. Now she opens her eyes every day. Her eyes are open wide. She's very different from she was. And then, just 2 lines below that, I think my mum's awareness of her surroundings and people visiting is improving every day. When people speak to my mum, she starts to look towards where she hears the voice coming from. She's recently started to look me and my family in the eye. In recent days, she started to stare at our clothes and we're wearing bright colours. She responds to the door opening and looks in that direction. Whenever we turn the tap on in the room, she looks towards the tap. And if we move on to paragraph 16, 4 lines down, it says, we have seen signs of her responding to me and other family members when we visit and are with her. I've asked her to respond to me by blinking, and she's done so. She's also moved her feet when I've been there. And she's tried to squeeze my hand and that of the grandchildren. I know these are signs, these are her ways of showing us she knows we're there. She can hear us. She can't communicate in any other way at the moment. She wants us to know she's fighting. She just needs more time. And then at paragraph 17, she makes a telling observation that when I tell the team about the progress my mum has made, then say she needs to be able to do different, more difficult things without recognising the progress she's already made. For example, when she first arrived at hospital, the team said she would need to open her eyes. When she opened her eyes, they then said she would need to show she can follow commands by tracking her eyes. They also said she would need to start breathing spontaneously. When she did that, they then moved the goalposts again and have said she needs to do other more difficult things that will take longer for her to achieve. Now, of course, one interpretation of that, one has the family member concerned that the goalposts are being moved. One, of course, can say, well, from a clinical perspective, one sees some improvement. Clinicians will say, well, we'd like to see more improvement again. And one wants, and there are good reasons, perhaps, for clinicians saying that. What we have here at paragraph 17 is a description of gradual improvement. I have to accept on my client's behalf that the medical experts would say this does not counteract, or this does not sufficiently override what we see on the EEG, what we see on the CT scan, and our other physical examinations, which say from a medical perspective, these are reflex actions, not actions of somebody who has any awareness. But there's a problem with that. And that is that the brain, as everybody knows, whilst it is vulnerable to damage, it's also remarkably resilient. And one cannot tell simply by looking at a scan, part of the picture. One can't conclude from looking at a scan in and of itself what a person's quality of life is and whether a person would gain benefit from their family around them.
What might be said in response to that, Mr. Thomas, let me just see what you say to this, is that in this case, it is possible to say from the extensive brain damage as disclosed by the imaging that the brain damage was comprehensive in the sense that it covered the whole of the brain. And this is a point made by some of the doctors and picked up by the judge, that this is, tragically, this is not a case of someone who suffered a form of brain damage which the brain is able to cope with, as happens, for example, with stroke patients in many cases. But because it's brain damage across the whole of the brain, save for the brainstem, that there is no prospect of the brain recovering in the way that you've postulated.
Well, Lord, that is the conclusions that the experts draw from the scans and from their stepping back and looking at it on a purely on the basis of the medical learning and the medical experience they have. I don't, of course, diminish that for a moment. But what it does not explain is the close, intimate observations of the claimant and her family members. So my client and her family members are the main.
So you accept that brainstem activity can cause involuntary movements findings, which in some cases can be misinterpreted by non-experts. But you say in this case, the evidence was that there was a response to specific stimulation by the family members,
Precisely.
which runs counter to
Yes.
that proposition.
I would have to accept the first observation. Yes, brainstem activity can be misinterpreted as awareness. That does not necessarily mean that that is the case in every situation.
Can I understand then? The judge made what seemed to me to be findings of fact in paragraphs 104 and 105. Do you say she should not have made those findings of fact, or that those findings of fact are open to challenge?
Lord, in relation to 104, those findings are not open to challenge. I am not in a position to argue, and I don't seek to argue, for example, that the CT scans do not show what the scan reports say they show. I can't challenge the medical investigations in that sense. I do say, in relation to paragraph 105, an assertion that XY has no discernible level of consciousness, and that is simply contrary to the very careful observations of my client and other friends and family over many months, which is that she does, these aren't simply reflex actions, these are responses to their presence. And the judge should not have gone as far as she did in the first 2 lines of paragraph 105.
She develops her reasons for that finding in the following paragraphs, doesn't she? She doesn't leave it there. She notes, she records, and she's mentioned this earlier in the judgment.
Yes.
What the family have said about XY responding to them.
Well,
That's right.
well, that's right.
And then she says none of the nurses and doctors or experts have observed it. That's right, isn't it?
Well, that is right, but they are simply not there for the prolonged periods of time that my client and other friends and family have been.
Yes. It's not just the experts who said this. I'm just putting this to test your
Yes.
argument. I'm not contradicting you in any way. I'm just testing it. It's not just the experts, i.e. Dr. Bell, etc.
Yes.
It's not just the doctors, the treating doctors. It's also the nurses, isn't it? Let's say that.
Well, it is.
So we're dealing with a group of people who have spent a very considerable amount of time with her,
Yes.
not on the scale that your client has spent with her, but nonetheless a very considerable amount of time.
Lord, you're right about that in both the observations you've made. There are nurses that have spent a significant amount of time, but not on the scale that my client
And
has spent.
the judge had before her, perhaps we should just help me just to test this by
Yes.
looking at it.
Yes.
The judge had before her evidence of what the nurses said. I know she had it in Dr.
Yes.
Bell's report.
I think it's Dr. Hutchings who's the treating.
Yes.
Dr. Hutchings. Yes, Dr. Just a moment. I'm sorry, I'm told that you may see this more clearly in the report of Dr. Wade.
I may have got the wrong expert. One of the doctors, I thought it was Dr. Bell. Forgive me if I'm wrong about that. Maybe both of them.
has the interviews. If we look at page 18 of the report of Dr. Bell, there is the section 6.3.
Yes, that's right. Section 6, he talks to staff and family members, starting with.
There's a clinical fellow, a consultant, and at
Is that-
6.3, the
that's
matron and senior
doc-
sister.
That's Dr. Hutchins,
Yes.
then the consultant, then the matron senior sister, then the physio, and then with your client.
Yes. And so you would have at 6.3 the views expressed of the nursing team to Dr. Bell.
Yes. Yes.
And it is right that Dr. Bell was told by the nursing team, for example, at paragraph 6.3,
Yeah.
from their perspective, there was no perceived change in the level of responsiveness to attendant family members, and no one had observed the motor responses that the family believed were present.
Yeah.
So that would be known, obviously, from the nursing side.
And
Of course,
let me
yes.
Give me a moment. And this, yes, so 6.3, I thought this is where it was, Dr. Bell. There may be more detail of it elsewhere in the papers, and if so,
Well,
I'd
the
like to
point is
see
made
it.
here. We don't necessarily need to look where the point is made elsewhere as well.
Thank you. Well, and we are dealing here with a patient in ICU
Yes.
who will be on, I don't know what the ratio would be, but certainly you'll tell me perhaps what the standard ratio is in ICU.
I might have to turn to Mr. Malonis for that particular one, but it might be 1 to 5.
But there'll be staff.
Not sure.
There will be compared to, as it were, ordinary wards, an intensive degree of a high level of nursing attention.
Yes. But Lord, yes, but still not on the scale of the time, both quantity and quality of time that my client has spent with her mother. Because, of course, and this is absolutely no criticism of any nurse, let alone the nurses at King's, they have a number of patients to deal with, and they have a number of other duties that are calling on their time, as well as, and they, whilst they will check and administer nursing care to patients, they don't have the time to sit with them and talk to them and pray with them, and to see the responses to that sort of those types of those quality of interactions, and no one expect them to.
Again, just to test your argument, if I may, against that, it might be said they don't have the time, but they have a greater expertise and experience in dealing with patients in this condition, and therefore it might be said have more experience in evaluating perceived responses.
Well, in general terms, I couldn't refute that observation. But we're not talking in general terms, Lord. We're talking about my client's
Yes.
evidence, and those of consistent with that of friends and family over
Yes.
many months with a particular patient. And of course, it may be the case that actions are possibly being misinterpreted by friends and family as meaningful responses that aren't. But it's equally possible that there are meaningful responses that aren't recognised to be such by the medical staff or the nursing staff. And that
Can I just take us back to the point my Lord was raising, which is about what the judge said about this.
yes.
At 106 onwards.
Yes, the judge here sets out the evidence and the types of evidence we just looked at in the report of Dr. Bell, and accepts that evidence. So that's plain, and it's the acceptance of that evidence that leads to her conclusions.
Okay, so it's really the whole, you focus on 105, but it's really 106 to 109, isn't it? Where she, as I said, explains her
Yes.
finding of 105.
More precisely.
And you've got to satisfy us today that there was a real prospect of you succeeding in persuading the full court that she was wrong. Is that too reductive?
That is correct. Wrong, not wrong in a wholesale fashion. It's sort of saying that the family are right and the nursing staff are completely wrong. It's not that at all. We're dealing here with the question of whether somebody who everyone agrees has got severe brain damage and has a prolonged disorder of consciousness, whether there is a degree of comfort and benefit that XY has from having her family around her, and a degree of responsiveness. So
Well, the judge does say that that is not to say at some level XY is getting comfort from their touch, but it's not a conscious sensation. I think she must mean not getting comfort.
Well, yes.
She does mean that, doesn't she?
Well, we come back here perhaps to where we started, which is that prolonged disorder of consciousness is not a single condition that affects everyone precisely the same way. And the judge has said, well, okay, I'm prepared to go as far as to accept that there's a degree of comfort here, but there's no consciousness on that. But of course, consciousness itself is not a black or white issue. The family's position is that there is plainly a greater degree of awareness than the medical staff have identified or for want of a better phrase, have given credit for. I don't mean that in any pejorative sense.
I'll just go back to your acceptance of the medical findings in paragraph 104. Just to understand, one of those findings is that there is no normal brain activity shown in 5 EEGs. Do you say that someone can have consciousness despite having no normal brain activity?
Lord, clearly not full consciousness, and clearly not what would be regarded as impaired consciousness, but specific awareness of what is going on around them. That's not what is being suggested. The family have seen and observed is a degree of response and a degree of comfort to their presence and to their interactions with her, which is not.
You say you can have that despite having no normal brain activity.
Well,
Just, I'm genuinely asking the question.
Yeah, well, I appreciate that entirely. The yes, in a word, a degree of what one sees in relation to the EEG tests and the CT scan cannot exclude what my client has witnessed, and the judge simply failed to recognise that. Lord, I wonder if I can move on to...
Yes, I think we've probably covered that
Yes.
point.
to the ground of appeal that does not in any way require you to go behind the medical evidence the judge accepted in this case. It's not a medical issue. It is a question of XY's own best interests. Individual with the values, beliefs, and convictions that she had. And there is a very simple legal evidential point to be made here. And that is that the judge found that, as we've already identified key paragraphs, 112 to 114, but in particular 112, that the court was not in a position to know what XY would think about the situation that she finds herself in. And we do not know what she would feel about the enormous pressure placed on her family and friends. Well, my lord, to put it simply and bluntly, that is incorrect.
Well, just so we're clear about what the judge was saying here, it follows on from 111, where it said that the judge says that XY has never stated her views about CANH or on sustaining her life artificially in the circumstances where she's totally dependent on others and cannot function in any of the ways she used to, where she is not aware even that her family is visiting her.
Yes.
So that's the premise for what is said at 112, isn't it?
My lord, yes. One needs to look at that premise very carefully because for two reasons. One is that even such an observation, one way or the other, cannot be said to be determinative for a number of reasons.
Sorry, just say that again.
So an observation that a patient has previously made whilst they had capacity cannot be determinative of what their views would be in the actual situation they find themselves in.
Yes.
For a number of reasons. An obvious one is time. You might have a case where somebody expressed a view many years before and their views might have changed. Their circumstances will change. One can see it, for example, that somebody might have expressed something only a year before, but before they became a parent. That's the sort of thing that could very dramatically change their views, either way, on these sorts of matters. They're often expressed informally. I know from many cases that it might be a television programme that prompts a discussion on the sofa.
You'll remember that I made that arose
Absolutely.
time ago in WNM.
Quite. And so for all these reasons, it is not the case, and it was, if this was the judge's approach, it was an error to say, well, if we've got a previously expressed view, we do know. We don't have a previously expressed view, we don't know. It wouldn't be right to say that a previously expressed view is conclusive, and it certainly wouldn't be right to say that a lack of a previously expressed view.
Well, what
similarly,
she says is, because she never had that sort of conversation, we don't know how she would feel in the current situation she finds herself in.
Well, the reason we can know what she would feel is because my client knew intimately over many years about her mother's faith, convictions and values. And her evidence on that is entirely consistent with that of the other friends and family who gave either oral or written evidence to the court. So this isn't the evidence of an anguished daughter, as one sometimes sees, of course, in these sorts of cases,
Yes.
where other friends and family say, I'm not sure that's quite how XZ would have seen things. They all speak on this point with a single voice. And not, I might add, with a single voice because they've all been prepped to say the same thing. What is striking, perhaps, in the exhibits to my client's statement is that the informal way in which the friends and family have expressed their views in those letters that are attached, I would suggest adds weight. They have not been passed through the filter of a solicitor. They are those individuals' personal expressions of what XY's values were and what her views were. Lord, I wonder if I can just take you through those. I'll take you through those as quickly as I can. We start with paragraph 22 of the judgment, where the judge summarised, as I understand it, the oral evidence of my client. Page 46 of the call bundle.
Yes, I've got that. I was just looking back. Yeah. Yes, thank you. 22.
Yes. She would choose life over death because she loved life. She said her mother would be upset if she gave up on her. She would have wanted her family to fight for her life. I'll come back to that phrase in due course. So that's the summary of what she said in evidence. If we come to her statement, it's in the supplemental bundle.
Yes.
It starts at C22. And the key paragraphs are 31, to start with 31, 32 and 33. So the section headed My Mum's Views. Perhaps I should start at 28. My mum is a committed Christian like the rest of my family. She has a strong faith and believes that it's God's choice when someone lives and when someone dies. My mum has remained alive despite the odds being against her since May, when she suffered a cardiac arrest. On the 6th of May, my mum died and was brought back to life. My mum would believe that there is a reason that God brought her back.
I'm very sorry, I've lost where you're reading from.
C34, paragraph 28.
Thank you very much.
Under this heading, My Mum's Views. My mum would believe there is a reason that God brought her back, and therefore that she is here for a purpose. To go against God's will would be wrong. If God had wanted her to die, then she would have died already, and she would not have been brought back to life. Now, that is not my client's opinion. It's my client's own opinion. It's my client's evidence about what her mother would think and what her mother would say. She then talks about some other matters before returning to this at paragraph 31, where she confirms, this is a point of course identified by the judge, although my mum and I never really spoke about what she would want to happen in these circumstances, I know she would want to be given the chance to survive. She is a fighter and she believes that it is God's choice when someone dies. She would want it to be up to God when she dies, rather than because the medical team make an active choice to remove her life support. If God did not want her to live when she'd had the cardiac arrest in May, then she would have died then, and she would not have been brought back to life. The fact that she's still alive now, after her body's been through so much trauma, shows that it's not her time yet. God will decide when it is her time. To withdraw life support prematurely would be to go against what God wants for my mum, or that might be my client's view. But she goes on to say, and what my mum would want, and what my family would want. And so we have in that one sentence my client's views, the views of the wider family, and the views of her mother. She then clarifies, I'm very grateful to Mr. Malonis for confirming his skeleton argument, that he accepts that the prior refusal to go back to hospital to get a pacemaker fitted did not mean she didn't place a high priority on her own life. It's simply because she was scared, in fact, about the risk of death if she were to have that pacemaker fitted as part of the process. She then says at paragraph 33, for my mum, life is the most important thing. She would not mind being ill or disabled. She would never choose death over life in any circumstance. My mum believes that life is precious and it should always be preserved. It should be God's decision when life ends, not the decisions of medical professionals.
Part of that appears in the judgment, doesn't it?
Well, it does, my lord, but it's difficult to understand how, having identified that part of the evidence, the judge nevertheless says, we can't know what she would have wanted, because that evidence makes absolutely clear we do know what she would have wanted. With at least as much certainty as if she'd had a specific conversation about suffering this sort of injury with her daughter before, because her faith would determine the outcome of any such conversation along those lines. It wouldn't be in any way logical to conclude that because XY's views about the end of life in general terms, and that it's God's will when someone's life comes to an end, apply generally, that she wouldn't apply that to herself as well. And that's a very important point.
Although you say that this stage of the argument doesn't depend upon going behind the medical evidence, don't we have to assess this question based upon the medical evidence, that the state of XY on the medical evidence, subject to your challenge as to the question of consciousness? Because when some of the factors that we're considering here, we'd have to say, well, how do these views fit with the findings in 104?
Well, yes. If my arguments in relation to the first of the two grounds I've focused on today is accepted to any extent, then that would strengthen the arguments on this point.
Yes.
But these arguments don't depend on success on that first ground, because what my client is talking about here are her mum's attitudes to life regardless of the extent of disability. So life itself, the sanctity of life that her mother clearly had very strong views about. Not only the sanctity of life, but crucially, that it is for God rather than for medical staff to determine when someone's life should come to an end. She picks up on that point in paragraph 36, and she's able to give a specific example of where her grandmother was ill. And she says the following. She describes some of the situations relating to her grandmother's terminal illness. And she says, 5 lines from the end of paragraph 36, the fact that my mum was so keen to fight for her mum shows she would want the same to be done for her. She cared and fought for her mum until the day that she died, because she believed that while her mum was alive, her life was worth fighting for. My mum believes in life and not death. And again, this isn't my client's opinion. This is my client's evidence about what her mum believes and what her mother's values. And lastly on this point, paragraph 38 on the same page. My family and I think the fact that my mum is still alive means there is still hope. That's their view, but we've also already heard that her mother had believed that God could do anything, something that she identifies at paragraph 36. My mum thought that with faith God could do anything. She goes on to say at paragraph 38, my mum is a fighter and would want to be given the chance to live. It is clear from how much progress she's already made that she's fighting to recover and to live.
Okay. And by chance to live, you should interpret that to mean including the chance to live as she now is, and on the medical evidence will always remain.
Lord, yes.
If not deteriorate.
For 2 reasons. One is that my client is able to say that her mother believed life was worth fighting for in itself. Her mother believed in the sanctity of life. And secondly, that her mother's views, that it very strongly held views, were that it was for God to take a life, for God to end someone's life, not medical staff. And the fact that she had survived the cardiac arrest, even with, of course, significant medical help, meant that God still had a purpose for her, and that is what she would believe. What she did believe. I can move on quite quickly, I think, to.
I just wanted to just remind myself, because this was considered by Dr. Bell, wasn't it? I think.
Well,
I say it was as in this
was.
point was covered by Dr. Bell at section 8.
It was. We're in a slightly odd position with Dr. Bell at this point, because of course he was primarily required to give a medical assessment of XY's condition and prognosis.
The reason I mention it is because the topic of this subject aspect of the case came up in his conversations with your client.
Yes.
And he reports on it at paragraph 8, I think it's page D55, 8.4, 5 and 6.
Well, my lord, in relation to 8.4, that is plainly a misunderstanding of the extent to which my client understands her mother's views on the sanctity of life. Because you have my client's own evidence that her mother had expressed those views. 8.5 is my client's own view on the withdrawal of treatment, and it is, of course, it is my client's view that to withdraw life-preserving treatment would be tantamount to murder. But that's I'm dealing here primarily with XY's views, not my client's views. And so the suggestion there's no point of reference to the patient's values and beliefs isn't correct, because her religious beliefs and values were very well known to my client and to other family members. And my lord, it is important that this isn't just my client's personal view, because I entirely see and accept that the evidence of one family member would not necessarily be determinative or even in some cases persuasive as to what the patient's own beliefs and values were. So we have at C41 the patient's oldest granddaughter.
Would you forgive me if I just went back to Dr. Bell? Was Dr. Bell challenged about this in his evidence? Because you say he was frankly wrong at 8.4.
Well, my lord, to say he was frankly wrong is perhaps overstating it.
Okay, I'm sorry. You say that that XY's views about it being a matter for God to decide, and her views around that should be equated with, I understand, the importance she attached to the sanctity of life.
Yes.
So it's wrong. It is wrong. You say he was wrong to say there'd be no discussion on the concept of sanctity of life. Is that right?
That is right, Lord. It is wrong if he thought that she had never expressed her views on the sanctity of life. That wouldn't be correct. He may be right to the extent that what he says is consistent with my client's own evidence. We never had a specific discussion about what
to do in these circumstances.
In these particular circumstances.
Yeah, but right. You say there is a point of reference as to her values and beliefs because of the views that she held about it being a matter for God.
Yes, yes. Not only that it's God's decision when to take a life, but that God can do anything. So God can preserve a life in the face, one might say, of medical science. And again, that may not be this court's view. That may not be the view of the doctors who give evidence in this case. But belief in the power of miracles is someone's values, and it's who that person is. And it may lead to their own wishes as to what their own best interests may be. That is made very clear again in the case of Y Valley and B, that it's not necessary for the court to agree with a person's views about whether they can beat the medical science. That is it. Again, and that's not a feature that emerges from the judge's assessment of what XY would have wanted in this case. Just then, Lord, very briefly, if we go back to the supplemental bundle at C41, we have XY's eldest granddaughter.
Yes.
I'm not going to read the whole statement, Lord, but slightly taken out of the narrative, she states, I think it's 13 lines down, I know with all my heart my grandma would not want the doctors to turn life support on her. She wouldn't want that at all. She goes on to describe what she has experienced in bedside, and that's
Yes.
I've made my submissions on that already. We then have at C43 grandson. And he says, there's a paragraph, this penultimate paragraph starts, it's not fair for someone who's still breathing. He says, 3 lines down, my grandma is a fighter, as I mentioned before, and if the roles were reversed, she'd fight for me.
Mm.
The reason that is significant is because what XY's grandson is saying is if I were in the situation that my grandmother is in, she would be saying, it's God's will. I may be paralysed. I may have very severe, irreversible brain damage. But I believe in the sanctity of life. And I believe my grandson should be allowed and should be supported to live until it's his time, until God says it's his time. And so, again, that is a very clear indication of the extent to which, knowing his grandmother, what she would want for him and therefore what she would want for herself.
Right.
Moving on to C45. This is XY's cousin.
Yes.
Very
Just
briefly.
these are do you want just to point out the places where you...
Yes, it's the first paragraph. 2 lines, second and third line. XY is a fighter who loves life. We know if she could speak for herself, she would tell us she wants to be given every opportunity to fight on. C50. This is quite a long account by a close friend of XY. And she says at it's 4 paragraphs in the end saying XY, better known as her nickname,
Yes.
is a gentle, warm-hearted, loving person. 4 lines down. She would be so proud to know that her daughter, along with family and friends, are fighting to save her from having the machine switched off. This is what she would have wanted. And again, this is somebody who knows how poorly she is and has visited her at the bedside as well. And then we have lastly C53. XY's niece, talking about her auntie. And it's 7 lines up from the end. Auntie enjoys life and loves her friend and family dearly. She would not want us to give up on her. Knowing she's alive on this earth gives her daughter, who's taking care of her mother on a daily basis, the strength to go on. Lord, that goes right back to, you'll recall, I drew this parallel when we looked at the Bournemouth and TG case.
Yes.
Where it is entirely legitimate and understandable for the mother a member of a close family to say or to express the views, if I am still a source of comfort to my family, I would not want that taken away from them. And so that is a very clear and objective support for the position that XY would not have wanted this.
Right.
This is an issue, of course, like any question of fact. It feeds into the best interests test, but the role of determining on the facts what XY's values are is something that ought to be resolved on a balance of probabilities. And on the balance of probabilities, we have on the one side a compelling, persuasive body of evidence from a number of different people, friends and family, saying this is to terminate life-supporting treatment is not what XY would wanted, even in this condition. And on the other hand, there is no evidence to the contrary. And so in assessing the balance of probabilities, the only conclusion the judge could have reached on this evidence was that the court could establish what XY's views were, and that XY would have wanted the treatment to continue. Now, that, my lord, does not reverse in itself the best interests decision that Mrs Justice Arbuthnot reached. But it is plainly a very significant factor. It's a very significant factor for the very reasons in the case law that I started with this morning. And so, my lord, if there is a real prospect of establishing on appeal that the judge was wrong on the evidence to say that they did not know, the court could not know what XY's views would be, but rather that on a balance of probabilities the court could conclude that it knew what those views were, that is a sufficiently material factor to require a reassessment of the best interests test. And one cannot say at this stage that a reassessment of the best interest test, taking full account of what we can tell XY's values and beliefs were, that would not reach a different decision to that outcome to that of Mrs Justice Arbuthnot. And so, my lord, for those reasons, there must be, on that ground alone, a real prospect of this appeal succeeding. To put it in a nutshell, my lord, there is a real prospect of succeeding because there is evidence from which one can comfortably conclude this is not what XY would have chosen for herself, this outcome. Therefore, the best interests test was very significantly flawed because it failed to take that factor into account. It follows from what I've said, and one does have to look at the application for permission to appeal in this context, and this perhaps comes on to the second reason for granting appeal. That is some other compelling reason. Now, if the court were to refuse permission in this case, the outcome of refusing permission would be that XY's treatment would be discontinued, and she would, it's a very high likelihood that she would die as a result of that. In circumstances where the only factual evidence the court has is that that is not what she would have wanted, and yet the decision that my client is seeking to appeal has stated the court couldn't tell what she would have wanted. And that by itself, what I would suggest, is a compelling reason why a full appeal, permission to have a full appeal in this case, should be granted. Well, before I stop, I wonder if I can just check
Yes.
with my client is at the back if there's anything else she wishes me to say.
Yes, just go back and have a word with your client for a moment.
Thank you.
Yes. Yes. Thank you very much, Mr. Thomas. As I said before, we're extremely grateful to you for your taking this case and for the obvious care you've taken in preparing and thinking about your submissions. Thank you. Mr. Malonis.
My lord, you've had an extensive skeleton argument from us.
Yes.
Is there a particular area or
Well,
issue
Mr.
you'd like-
Thomas has focused on 2 points. I think for my part, I'd like to hear what you say about those, particularly the second.
Can I start off then, just dealing briefly with the medical evidence, because that seems agreed that it's all one way, but all one way with an important gloss so far as the future is concerned. The starting point must be Dr. Bell's conclusion, which is agreed by all the others, in the supplementary bundle D47 paragraph 4.1.
Mr. Malonis. Yeah. Yes.
4.1, his overview of the above clinical picture was that XY is at the lowest point of the PDOC spectrum
Yeah.
and
Right.
would historically be referred to as in a persistent vegetative state.
Yeah.
And then so far as what Mr. Thomas has described as the recovery, that is, as your lordship identified, only a recovery insofar as it was a move out of, a transition from coma into PDOC, where in PDOC, which didn't occur in coma, there was a sleep-wake cycle and an opening of eyes. And
Yeah.
completely understandably, that is viewed by the family, who are desperate for any sign of an improvement, as some meaningful response and perhaps the first steps on any path to a greater and fuller recovery. Regrettably, all of the medical evidence confirms that simply is not right. And we referred in our skeleton document to the imaging, partly because images sometimes convey in a way that words don't the reality. And that is why the most recent CT imaging on the 22nd of October, that was before her ladyship, had demonstrated further atrophy of the brain. This is not even a stable condition. It's one that's deteriorated over the relatively short period of XY's admission.
Just remind me of what part of the judgment you're referring to, because I have seen it, but I
My
haven't
lord,
picked it up.
It's page 104. Thank you. It's page 57 and paragraph 104,
Thank you.
and that deals with the other issue I was
Oh, it's the
going
passage that we've been looking at.
Indeed.
All right, I'm sorry.
The final sentence deals with the CT scan, and the sentence preceding, I think my lord also referred to earlier on, the EEG tests have been undertaken
Yes.
and show no normal brain activity, arguably a worsening position. That then leads into the other important point in that passage, which is as to the perceived responsiveness. And that was put to Dr. Bell by me, and his response is set out at paragraph 108.
Yes.
When he was asked what the prospects were of there being any meaningful response, and he'd obviously both spoken to and read XZ and read all of the other evidence, and he said that would be outside all accepted medical knowledge. So there is no prospect that there has been any meaningful recovery other than from coma to PVS, or that there could be any any responsive or purposeful interaction with her environment, or regrettably with any of those around her who visit and sit by her bedside. That I'm afraid, is the agreed medical evidence. That is to be contrasted.
I know. I had observed that. The laws observed to me, but something I'd observed that your client has just left court.
I wonder if I could.
Do you want just to pop out?
Just pop out and see.
And we'll just see if I don't know why she's left or whether we should continue. I did see that. We'll rise for a moment, Mr. Milonis, and it may well be the family would like to hold Mr. Thomas. Let us know when we're ready. Thank you.
Okay, I think she's just going to be a couple of minutes. I think she'll just be a couple of minutes. Okay.
Michael? Sure, we can do all that.
They say how long they were writing for.
A couple of minutes. They just said to let them know when.
Oh, okay. To let them know. Fine. Is the feed, presumably, is the live feed still running?
I can check. Hold on. I think it is. just sent you two books. I've just sent you. Okay. So you want to do CRS?
Either CRS, which is probably what it's on.
Sounds evidence.
Is court ready? Court right this evening?
Yeah. Yes, Mr. Lovis.
Thank you. Those findings as to the imaging and the EEG results fed into the judge's conclusion at paragraph 120, where she considered the prognosis if clinically assisted nutrition and hydration was continued. And she found there that there was no prospect of recovery of any function. She recited again the CT imaging, which showed a deteriorating situation in essentially a shrinking brain, which was demonstrably worse than the original scans in May. And then a deteriorating brain will not result in an improved prognosis, and she found a continuation of CANH will not change that prognosis.
Yes.
I move away from that, but it is a fundamental basis upon which any assessment of best interests must unfortunately lie, notwithstanding the family's sincere hopes and beliefs that there is some meaningful response. And for the trust, the nurses who care for patients such as XY see this frequently. There are reflexive movements which give hope to family members, which regrettably it is often the duty of the clinicians and the nursing team to undermine by pointing out that these are, in certain cases, more likely simply reflexive brainstem mediated responses. The Lordship asked as to the intensity of the nursing care, and that is one-to-one at all times.
Well, I thought it was sort of confidently said 1 to 5. My understanding is that ITU it's normally 1 to 1.
It is one-to-one, and that was confirmed. Ms. Bogle, who sits behind me, has emailed Dr. A, and that's been the response.
I mean, that wouldn't obviously mean a nurse would not be standing there 100% of the time, 24/7. But the ratio is 1 to 1.
Indeed.
In other words, there will always be as many nurses on the unit as there will be patients.
Yes.
I mean, they may be coming and
Yeah.
going and doing all the things they have to do. Yeah.
And in particular, we mentioned, because the family may take this amiss, the nurses are usually careful not to overcrowd the family and patient
Yeah.
when the family are there. So the family might say, well, they're not always there when we're there, and there's a reason for that, because the family are given privacy with the patient. The second point.
And another point, of course, is that the nurses, these are specialist nurses.
Yes.
Yeah.
And my lord, the point that moves on from the one-to-one nature of the nursing care and their specialisation feeds into your question about the structured assessments, whether there are WIM or
Yes.
SMART assessments.
Well, that's right, smart. Are they done less frequently now than they used to?
They're done less frequently in this scenario because instead of WIM and SMART testing, which might be carried out, one effectively has an assessor who comes in and carries out the testing on 10 occasions.
Yeah.
With XY, there was CRS, coma recovery scale testing carried out.
CRS coma. Yes.
Which was conducted daily by the staff, which Dr. A dealt with in questions from me and confirmed that that had showed a deteriorating condition with no improvement.
Okay. Is that covered in the judgment?
That's not in the judgment. And regrettably, those results were not in the documents that were before her ladyship, but it was evidence which Dr. A provided.
So he confirmed in evidence that that testing was carried out.
As I say, CRS testing.
Yeah. And showed.
And showed a deteriorating picture with no recovery.
So is it the practice then is that those tests are carried out on a patient in ITU in these circumstances automatically? And in those circumstances, is this your case? WIM and SMART testing is not. How would you put it?
It's not ordinarily
conducted. So WIM and SMART testing might be conducted for a patient who had been, who was not in ICU.
Oh yes.
Yeah. Okay.
I think I'd have to take instructions before answering any more detailed questions about
okay.
that. That was
Right.
certainly my understanding from Dr. A.
Yeah.
But all of that feeds into, and I don't propose to spend any more time on the medical issues for obvious reasons.
Yeah.
That feeds into the submissions that were made by Mr. Thomas in respect of XY's beliefs and particularly the weight she applied to life. And with as much eloquence in his written submissions as in those he made orally, there was, we would respectfully say, some overstatement of what could be derived from XY's past conversations. Because as the judge properly identified, the issue had never been discussed with her.
What Mr. Thomas was really submitting, and I don't want to be too reductive, is that XY's views, religious views and faith, that it was a matter for God to decide, not man, encompassed a view about what would happen in this situation, even though there was never a specific conversation about it.
And what we would say about that is, in relation to what her views were and how they were expressed, there is not the benefit of a discussion between XY and either XZ or any other family member in which she said, if I am in this condition, I want everything done to maintain life. And I put it in that way because in the TG case, that is specifically what was found. So if I can just jump, I'm not going to deal with the authorities very much, but if I can just by way of contrast, take you to the authorities bundle at page 529.
This is Sir Jonathan, is it?
It is
Oh, Sir Jonathan. 529.
529.
Yes.
And at the top of the page, paragraph 24, the judge says, I start, of course, with her husband, and I've been struck particularly by paragraphs 25 to 31 of his statement. Paragraphs 8 and 11, he recites some more. Unfortunately for us, he says, I'm not going to repeat them verbatim in the published judgment. They're very much in my mind. But notwithstanding the lack of repetition, what he derived and what the official solicitor, Miss Roper, will come to in the following paragraph, derived was the following. There were two principal strands. First, that if her presence was a comfort to others, as I find it to be, she would want to be there whatever the cost to her. Family was central to her, and she would want to remain a part of the family no matter what form it would take, for as long as possible. Then he refers to her having had the utmost respect for life because of its intrinsic value, and as was said here, for no one other than the law to take it away. Moving, if I can, to paragraph 25, what Miss Roper said there in her position statement in the second line was that there was compelling evidence that TG would not have consented to the ET tube being removed, and that she would have wanted to benefit from the opportunity to live and take whatever chance is offered, however small, of improvement in her condition. Well, that is different and much more specific than the situation that was before the judge below. And the descriptions provided by all of the family members are of a fighter. The fact that she would have wanted them to fight or would have fought on their behalf if the roles were reversed is repeated throughout. But also the fact that she would have fought because she enjoyed life. She loved the community, her church, her cooking, her entertaining, her discussions with friends, chatting with friends from Jamaica about the old times. And there is never any chance of a return to that. And that, my lord, I think takes us to what Lady Hale said in Aintree.
Yes, which we haven't got, except
We haven't
in our memories and somewhere, no doubt, quoted in these judgments.
Unfortunately, the paragraph that I think your lordship wanted to look at isn't in the judgment.
That's 45 was one in my head.
Indeed, and it's the second half of 45. I don't know whether a copy is on the screen to your lordship's right, but if I read out the second half of paragraph 45, her ladyship said this: even if it's possible to determine what his views were in the past, they might well have changed in the light of the stresses and strains of his current predicament. In this case, the highest it could be put was, as counsellors agreed, that it was likely that Mr. James would want treatment up to the point where it became hopeless. But insofar as it's possible to ascertain the patient's wishes and feelings, his beliefs and values, or the things which were important to him, it's those which should be taken into account because they're a component in making the choice which is right for him. So one has to be extremely careful about the way, or about the reliance and weight placed on previously expressed views, unless they are very specifically expressed views. And the idea that XY's views about wanting to be with those around her and wanting everything done because she believed in God's will have to be taken into account when considering, first of all, the medical evidence, and secondly, the fact that she can never leave an ITU, partly because she requires ventilation with the ET tube, but also significantly in this case because of the complication that requires her to have the bite guard in place. She requires sedation. It was 3 times weekly. It's now, I think, 1 to 2 times weekly for the cleaning of that, and that can only be carried out in an ITU. So she will remain there for so long as she lives. She will be subject to all of the invasions of being on the ITU, including the suctioning, including any blood testing, the invasive measures required for cleaning her. Your lordships will be familiar with all of that. And all we would say in response to Mr. Thomas's submissions in respect of what she would have wanted at any cost is she would never have envisaged this cost. To somebody who has not either read of or heard of this level of intervention and invasiveness, it would not be in their consciousness or contemplation. And respectfully, we say that in considering what her views would have been, she undoubtedly did say and would have said to her daughters and to those around her that she would want, that she valued life because of what it gave her. The opportunity to play with her grandchildren, her children, to engage with all those around her. She can never do that. And the cost of her subsistence now, because it's not even an existence at the level it currently is. That is, we say, far too grave a weight for her to bear. The doctors realise that. My Lord, that's why we oppose the application for permission with regret and sadness and the greatest of sympathy for XZ and her family who have presented the case for XY so strongly.
Thank you. Any more questions? Ms. Roper, how long do you think you're going to be?
My lord, probably not very long unless there's anything specific on which I can help you that Mr. Milo.
I think we're listed for half a day, I'm not sure. We could rise now and come back at 2, or we could, but I don't want to cause distress for the family. We normally rise at 1 o'clock, but we could carry on if that was all right, to finish whatever you want to say, and then Mr. Thomas has the last word.
I'm in, I think, your lordship's hands and to some extent those of Mr. Thomas and his client. I'm very happy to do whichever suits both you and her best.
Yes. Just a moment. Just so you know our thinking about judgment, we want to think very carefully about what's been said today. So I don't propose that we should give judgment today. We have to give judgment quickly in this urgent case. And my current thinking is that we would do this on Friday. So if that helps. I think in those circumstances, we'd like to hear you now, Ms. Roper, and Mr. Thomas, if that's convenient for you, we'll carry on now. Thank you, Ms. Roper.
Thank you, my lord.
You've obviously read your submissions.
I'm grateful, my lord, and you've obviously heard the submissions of Mr. Milonas as to the medical evidence.
Yeah.
With which the official solicitor agrees. On that point, we say simply that the position in front of the judge was that the family were very clear that they believed they had seen multiple signs of responsiveness. The clinicians had not seen those signs themselves. That included Dr. Bell, who had attended with the family members. I think that's referenced in Mr. Milonas' skeleton. And he refers to this at D44 to 45
Yes.
of his report. He says there that he was satisfied. He goes through multiple factors.
Yes.
What he says.
Yeah.
He says there, he goes D44 to 45, he goes through multiple factors which he says this would not impinge on her representation, and he concludes at 3.10 when considering all of the above elements, I would conclude that XY's presentation on the day of my assessment was representative of her underlying consciousness. So those were the circumstances in which he didn't himself see the responses that the family saw.
Can I just, will you just give me a moment?
Of course.
He goes on to describe what he saw in the following pages, doesn't he?
Yes.
Thank you.
My lord, the clinicians who gave evidence were not saying, they did not assert that the family's evidence was necessarily wrong. They were not in a position to, as to what they believed they saw. So they were not saying that the family were
They were not challenging what the family
Yeah.
said they saw.
they were not challenging what the family said they saw, but they said if it was there, that those signs did not indicate awareness or responsiveness as the family believed. That is a question of interpretation, not only of physical evidence and reported observations, but also the basis of their combined and very extensive expertise, and that with the benefit of the CT scans and the EEG scans which have been done. My lord, you asked about the nursing care.
Yeah.
That is referenced in one place which I don't think you've been taken to, which is in the attendance note of the agent who went to visit XY.
Oh yes, I have read her note last week. I haven't reread it for this week. Do you want to take it to it?
If I can take you to that, my lord, it's at
This is Miss Hobie Hampshire.
58.
Yeah. It's Hobie Hampshire, isn't it? Yes, that's right.
And you will see that in paragraph 1, she conducted her visit with, I'll look to Mr. Mylonis to see if I should say those names out aloud.
But do we don't, well, other members of staff.
Just to identify, the first one is a consultant, and when she refers to her colleague, who begins with E,
Yes.
that is someone who is identified in the medical records as the matron.
Okay.
And so someone who would have understood, have had probably more regular contact with XY.
So just so we all know, it's not clear to anybody watching.
Yes.
I've been referred to the attendance note on behalf of by your instructor solicitors on behalf of the official solicitor.
Yes. So my instructing solicitor at the official solicitor's office instructed an agent, Miss Hobie Hampshire, to go and visit XY in Holt.
Yes, that's right.
And there's a detailed attendance note of her, which includes a record of her
Yes.
visit. And in terms of, this is clearly a layperson's, not a medical attendance note,
Yes.
but it does provide additional information as to what the nurses' evidence might have been if they had given their own statements. At paragraph 10, the matron says, she has remained static with no more progression. And then turning back to the list of primitive reflexes, she said, we haven't seen her do anything else. Then there was a brief discussion about the fact that she does also bite on the bite guard. At paragraph 14, they discuss XY's eyes moving. And the consultant says they will move in different directions. It is not volitional and not in response. She does not fix and follow. They can move in an uncoordinated way. I have never seen her track. And the matron agrees with the above summary and adds, I know the family report differently. I can only say what I observed. She concluded, I haven't seen a reproductive report before saying I can only report what I have seen. And then at paragraph 22, the consultant and the matron agree that XY's presentation at this attendance was as wakeful as she gets. And at paragraph 24, and this is perhaps the most helpful point, the matron says, the nurses are here when the family is here. We have never disputed, for instance, that our eyes are open. We do document it. I'll say, for instance, it could be a reflex. I try to explain things. The nurses are here when the family are here. The nurses would escalate it if they saw something different. My lord, on the medical evidence, that point, the simple point the official solicitor makes is that the court heard detailed evidence as to XY's neurological condition. It was recognised that there had been an early trajectory of change, as Mr. Milonas referenced, but critically, the medical evidence was unanimous that there was no prospect of further recovery in the way hoped for by her family. And that was the finding that the judge made. We would submit that there's no evidence suggesting there's a real prospect of a full appeal court concluding that that finding is wrong. And my lord, that is the context in which any consideration of XY's wishes, feelings, beliefs and values must of course be situated. There was very clear evidence that XY was a deeply religious woman with a strong faith in God. And you have the evidence of ZZ that her mother would believe there was a reason God had brought her back from the brink of death after she arrested. And that she said that her mother would want it to be God's decision rather than clinicians as to when she dies. And those matters are, of course, potentially relevant, we would say not determinative of the question, both of her wishes and feelings and her underlying beliefs and values within section 4 of the MCA 2005. But of course, those had to be considered in the actual circumstances as the court concluded them to be. And XY had not had any discussion with her family as to what she might want for herself in those circumstances. In circumstances where she had no prospect of leaving the critical care unit, no prospect of being liberated from invasive treatment, and no prospect of any neurological recovery. The family's beliefs as to what she would have wanted in those circumstances was of course situated, because it had to be, in their belief that she was responding to them and that there was potential for her to recover. And my lord, in our submission, the judge was entitled to conclude that the family evidence did not lead to a finding that XY would have wished all life-sustaining treatment to be considered in those circumstances. She considered the family's evidence, their belief that XY would have wanted life-sustaining treatment to be continued, but ultimately she refused to draw that inference, and the official solicitor submits she was entitled to do so on the evidence. The simple fact that an individual has a strong faith does not inexorably lead to any particular conclusion as to what they would want in the particular circumstances in which XY is situated. Mr. Thomas suggests on behalf of the appellant that because XY believed it is for God to decide when someone dies, she would have wanted life-sustaining treatment to be continued, but again, our submission is that that is not a necessary inference. In closing submissions, the official solicitor submitted that granting the application would not mean the court would determine the time of XY's death. It would cease medical intervention which began on the 6th of May when she arrested. And the judge said in her judgment, paragraph 115, withdrawal would not inevitably lead to XY's immediate death. In essence, we say we have that the official solicitor has immense sympathy for the family's position, but that the inferences which you are being asked to draw are not necessary inferences on the basis of the evidence. And we say the judge was entitled to conclude, as she did conclude, that it was not possible to say with any certainty what XY's wishes and feelings would have been in these precise circumstances, or what conclusion her beliefs and values led her to.
I think Mr. Thomas submitted it was a matter to be determined on the balanced probabilities what her wishes were. You said the judge, not possible to say with certainty. I don't think I'm not sure Mr. Thomas would go so far.
I think at one point he said with almost complete certainty, but we would agree it's something to be determined on the balance of probabilities.
Okay.
And on the balance of probabilities, she was entitled. Yes, she was entitled to conclude that it was not.
I think what you're saying is it's not for this court to interfere.
Yes,
The grounds are not there for us to interfere in her evaluation or her decision as to what is the proper inference.
Yes, my lord, that is indeed what I'm saying.
Thank you. Thank you very much, Ms. Rowe.
The only very small further point I would make on the TG case, which Mr. Thomas took you to, is that the circumstances, the second point I was going to make is the same one that Mr. Mylonis has made. The evidence there was, as the judgment records, very specific and detailed, and it did lead the judge to conclude, to draw an inference on the basis of the evidence as to what TG's wishes would have been in those specific circumstances.
The official solicitor's submission in those cases position was different too, wasn't it?
Yes, they were very different.
Thank you.
And that is because the evidence was different.
Yes, well, the facts.
But the other matter that was different in the TG case that's referenced at the beginning of the judgment is that TG's circumstances were also different in that not only was the application made very soon after the original incident, but she did have the prospect of a tracheostomy and she did have the prospect of leaving critical care unit and so eventually being transferred to a nursing home and to a life which would not have exposed her to continuous invasive treatment. That is referenced at the beginning of the judgment. That's rather than something I'm
Thank you.
from having been involved in. My lord, unless there's anything else
I don't think so.
we
Nothing.
can assist you on particular.
Thank you, Ms. Webber. Can I just go back to Mr. Mylonis for a moment? Do you want to say anything about if we refuse this application, what do we need to say anything or about the palliative care programme?
Well, I'd alluded to that in the closing paragraphs,
Yes.
because for understandable reasons, perhaps the family have not been keen to engage in anything which would bring forward the date of withdrawal, but regrettably there has to be a time frame. We had originally envisaged that discussions take place within 5 days of the judgment being handed down, and that the withdrawal take place within a week of that. And I think we'd be asking for a similar time frame. So 5 days from the date of your lordship's judgment.
5 days after judgment for discussion, and withdrawal to take place after that.
Yes. And in terms of just trying to anticipate what might be raised, it would plainly be best, we think, for Dr. A, who has been the lead clinician throughout, to be at those discussions. So they should be at his convenience insofar as that can be managed for X.
Well, I think that's a sort of detail which this court would not get involved in. But what you are just thinking of what, again, I'm talking hypothetically, if we're minded to dismiss this application, you would propose, we would record in our judgments that this is the trust position, that there would be no attempt to implement the order for at least 5 days to allow discussions to take place, and any further application that was necessary in those circumstances by any party would have to go back to the judge. Thank you very much, Mr. Mallows. Mr. Thomas.
Well, thank you. Just 4 very brief points. Firstly, in relation to the report of Dr. Bell that we were looking at briefly with my friend Mr. Linus.
Yes. Yeah.
In relation to the responsiveness that Dr. Bell found,
Yes.
my client is concerned, and I think it's not in dispute, that on the morning of Dr. Bell's assessment, the XY had been given a
Sedation.
Yes, precisely.
Wasn't this considered in the?
It was considered by Dr. Bell. Dr. Bell's conclusion on that was that would not cause the degree of lack of responsiveness that he found. But it is my client's evidence, and it was her evidence to the court that after she has had that medication, she is less responsive, and she did not see. In the hours after that medication was administered, the responsiveness that she would see on other occasions.
So her evidence is that it did, as a matter of fact,
certainly made a
impinge
difference
upon the level of responses.
Yes.
Even though Dr. Bell said it wouldn't.
Well, Dr. Bell's position was that it wouldn't. It wouldn't.
It wouldn't from a scientific point of view or medical point of view.
Yes, anti-seizure
But
medication.
your client's evidence is that her experience was that it did.
It would not create it would not lead to the lack of responsiveness that he found. That's what his evidence was. But that's to be put in against my client's evidence as
At that point. Yeah.
Secondly, and very briefly in relation to the standard proof, to the extent that it was a finding on the facts that the judge needed to make, the standard proof, I think we all agree, is the balance of probabilities. My position was simply, in saying near certainty, was that from my client's case, it is comfortably beaten.
Yes.
For the reasons I said, there's lots of evidence on one side and no evidence on the other, and that's why we're able to say the judge, we can go as far as to say that the judge was wrong to say we do not know. Because in fact we did know, or we do know. Dealing with the Aintree case very briefly, my lord, which now is effectively before the court, even though not in the authorities bundle. What the Supreme Court said at paragraph 45, I think we've already really ventilated, which is that firstly, even where the court knows somebody's wishes, they don't automatically prevail. I think we all agree on that. We can't always have what we want.
Yeah.
They make the point that I made also in submissions, of course, there, that somebody's views can change, both over time and potentially faced with the reality of where they are in a hospital bed. That is all accepted. But very importantly, and this was not specifically before the court in the Aintree case, but is before the court in this case, as it was in TG, what you have here, my lord, is very clear evidence of a strongly held religious belief, which is the basis for the views the evidence for XY's views as to the end of life, that it is God's decision and it is God's will and not hers. Those views, I would submit, are far more likely to persist and far less likely to change based on the individual circumstances that one finds oneself in. And to the extent that, again, without going back over the evidence, you recall the evidence of her grandson, that if he were in his evidence was he were in her position, she would be fighting for him as they are fighting for her, even if he were in the state that we have in this case, because of, in part, because of her strongly held religious views. And lastly, my lord, and this is a very quick point, I don't understand either of my own friends to be suggesting that if I am right, or if you'll accept my submissions in relation to the flawed approach to this part of the best interests determination, that you could otherwise, that you could say, be that as it may, that the best interests conclusion can stand.
Not at this stage.
Certainly not at this stage, my lord.
I
So-
don't-
so
I
it
don't,
would-
I don't understand Mr. Milonis Roper to have submitted that, so
I don't need to address that.
thank you.
Thank you.
Thank you very much. Well, we're very grateful to all of you, all three of you, and also to those who sit behind you. And if I may say so, also to your client, Mr. Thomas, for the way in which she's put the case forward when she was acting in person. I know she's had the benefit of representation latterly, but she's had to do a lot of the work herself. We're very grateful to her for having, for the way in which she's done that, very clear way in which she's helped us. This is an important decision, and we're going to reserve our judgment. It's an urgent decision, so my hope is we will be able to give judgment on Friday. We would like representation if possible on Friday. We will let you know on Thursday if there's going to be any further delay, but that is the current timetable. That's the best we can do in the circumstances. On this occasion, I will propose the judgment will be delivered under in the old way of being read out rather than handed down again to save time, with no need for drafts, etc. We'd be grateful if you would consider between you the possible orders that might be made depending on our decision. Thank you all very much.
All right, the table.